Hi, this is Silver de la Rosa and I welcome you again to On Silver Screen, where learning is interesting. We are now at episode 4 of our contract practice season, and today we are going to discuss the conditions of contract. If you like watching my video, please hit the like button, and you can also share the video to your friends, especially those who are preparing for their EPC. And if you haven't done yet, please subscribe to my YouTube channel and turn on the notification bell so that you will be notified every time I upload a new video. Our discussions for this episode will be the general and particular conditions of contract. We will also get to know what are the general provisions in the standard conditions of contract. We will try to differentiate between letter of acceptance and letter of intent. We will also get to know who are the parties to the contract. And we will discuss the difference between assignment and novation. We learned from previous episode, that is episode 1 of this season, when I discussed about contract law, that the conditions of contract is a fundamental term, that if breached, gives the aggrieved party the right to either terminate the contract or affirm it. And in addition, the aggrieved party can also claim for damages. Now, there are two types of conditions of contract. One is the general conditions. The other one is the particular conditions, or sometimes known as specific conditions of contract. What are the difference between these two? Let's find out. General conditions of contract is a portion of the contract document in which the rights, responsibilities, and relationships of the parties involved are itemized. It defines each contracting party's duties and privileges and the rules that will govern this relationship. The general conditions in a standard form of contract are applicable to most projects where the standard form is used. So it is applicable to most projects or to any project as long as you use this standard form of contract. Let us take a look at particular conditions of contract. It is a document which sets out the project-specific requirements, additional terms and conditions, clarifications and amendments to the general conditions, and or any other documents included in the contract that have been agreed by the parties in writing in respect of the contract. So this one is specific to the project. Anything that you wanted to amend from the general conditions, you will do it in the particular conditions. Or any additional terms or any additional conditions that the parties had agreed specific to the project, it will be included in the particular conditions of contract. Let us now take a look at the terms that are commonly included in general conditions of contract. These are the general provisions, parties to the contract, quality, assurance and control, price and payments, time, changes, suspension and termination, risk and responsibilities, claims and disputes, and the completion of the project. For this episode, we are going to focus our discussion in the general provisions and parties to the contract. Now, let us talk about the general provisions. In this section, it provides the general guidance governing the general use of conditions of contract and the interpretation of terms embodied in it. The following may be included in this section: definition and interpretation. It is important that on the onset, the use of terminologies are defined to avoid misunderstanding. Let us take, for example, the term the contract. From previous episode, I defined what is a contract. But in the context of general conditions of contract, the contract means the contract agreement, the letter of tender, the letter of acceptance, these conditions, the specification, the drawings and the schedules, and any further document which are listed in contract agreement or in letter of acceptance. This is the definition of the term the contract in FIDIC Red Book 1999. You can check your own contract and see what is the definition of the term the contract. It may be similar or it may have a different context. Now, we have another term here, letter of acceptance. What is a letter of acceptance? Letter of acceptance, or LOA, is a formal written confirmation indicating the employer's acceptance of the technical and commercial part of the contractor's letter of tender. So it is only accepting the technical and commercial part. of the offer. In some instances, LOAs are issued while parties are still negotiating the contract terms and conditions, and once agreed, the parties will sign a contract agreement. Meaning, the letter of acceptance can be issued even the terms and conditions are not finalized yet. And in some jurisdictions, LOAs are binding documents, and the receipt of LOA represents the commencement of the contract between parties. Now, let's take a look at letter of intent. What is a letter of intent? The term letter of intent does not have technical legal meaning. It is essentially a communication expressing an intention of the client to enter into a contract with the contractor at a future date. So it is only expressing your intention to form or to have a contract with the contractor. But the contract was not issued yet. Now, the question oftentimes arises is that, is letter of intent legally binding? Before we answer this question, let us take a look at the different types of letter of intent. First, there is what we call the comfort letter. It is a non-binding statement of the future intention to enter into a contract with the client. Comfort letter in a sense that you are assuring the contractor that you may enter into a contract with him in a future date, or you may award the project to him in a future date. Another type of letter of intent is what we call an interim contract. It is called interim because the terms fall short of the terms of an intended final contract. It may also contain instruction with consent to spend. But be careful when you carry out the instructions from this interim contract or this type of LOI, because if the instruction only allows you to carry out the mobilization first, then just do the mobilization, nothing more than that. Or if the instruction provides you to spend X amount of money, then you have to spend only up to certain amount of money. The next type of LOI is a binding contract, where the LOI incorporates the final terms and conditions and recognizes the existence of a binding contract. So going back to our question, are LOIs legally binding? The answer to this is the content of the LOI will determine whether it is legally binding or not. It is therefore important that you read and understand the content of your LOI. Other than the definitions and interpretations, the general provisions may also include the following clauses. Communications. This describes the accepted means of communication and delivery method of documents. Nowadays, we are fond of using emails and messaging applications. You have to take a look at if this mode of communications are accepted means or official means of communication under your contract. Because, for example, if you send a notice of delay through email, and this email is not considered as official communication, then your notification is not valid. It is therefore important that you have to understand what are the accepted means of communication under your contract. Law and language. It provides the governing law of the contract and the language to be used for communication. It is important that you understand what is the governing law of the contract. It may be the law of the land where the project is located, or it may provide that the governing law will be the law of the territory where the paymaster is located. You have to be very careful because it will have an implication in the event of dispute or settlement of dispute. Care and supply of documents. This describes the document that will be supplied by the parties, the number of copies, where it should be kept, and so on. Use of documents. This clause describes the terms of use of the documents provided by the parties. It tackles the issues regarding copyright and intellectual property rights of the documents. It is important that you know the extent of your privilege to use the documents issued by the other party. Priority of documents. Priority of documents is a clause that lists the contract documents in order of its precedence. In the case of any inconsistency or ambiguity, the document that is higher on the list will govern. For example, contract agreement, letter of acceptance, particular conditions, general conditions. So if you notice, particular conditions is above general conditions. If there are any discrepancy or inconsistency between the general conditions and the particular conditions will prevail. Specifications, drawings, schedules, and other documents. Again, it is oftentimes that we find discrepancies between the drawings and specifications. If the documents are listed in this manner, we can see that the drawings are below specifications. So in any case or in any event that there is a discrepancy between drawings and specifications, the one that is written in specification will prevail. That is what we call priority of documents. Let us now talk about party to the contract. This section describes who are the parties to the contract and what are their respective rights, roles, and responsibilities. Now, who are the parties to the contract? We all know that a contract is an agreement between the client and the contractor. So that is how a contract is formed. It's an agreement between the two parties. We must take note, however, that parties to a contract cannot confer rights or impose obligations upon any person who is not a party to the contract. So this principle is called privity of contract in common law. But we all know that in construction, there are a lot of parties involved. In the pilot episode of this series of videos, we know that there are other professionals in built environment or in construction, such as the architects, engineers, project managers, facilities managers, and quantity surveyors. Other than that, we have subcontractors, contractors design team, and suppliers. So how are we going to bring all of them into the contract? Because they are not party to the contract between the client and the contractor. This is where the collateral warranty will play its part. A collateral warranty is a supporting document to a primary contract where an agreement needs to be put in place with a third party outside of the primary contract. So that is collateral warranty. I will talk more about collateral warranty when I discuss warranties and guarantees, warranties, and bonds. There are several ways to incorporate a third party into a contract. One of them is through assignment. Assignment is the transfer of benefit or interest from one party to another party. While the benefits can be transferred to the assignee, the obligation or burden behind the contract remains with the assignor. So note that in assignment, only benefits or interest are transferred. The burden or the risk still remains with the original party in the contract. Let's see how assignment works. For example, we have this client and the main contractor, and they have a direct contract. The contractor will build a house for the client, and in return, the client will pay the contractor a certain amount of money. But the contractor also has a direct contract with the bank, for example, by way of loan. The contractor can assign its benefit from the client to the bank. Therefore, the client will pay directly to the bank, not to the contractor. So the direct link of payment or the direct link of benefit will now go to the bank instead of the contractor. But in the event that the client will default on its payment to the bank will not chase after the client. It will chase after the contractor because the client don't have any risk for the bank. It is the contractor. What the contractor has transferred is only its benefit and not the risks. This is how assignment works. Another way to bring in a third party to the contract is through novation. It is the transfer of both benefits and burden with the contract to another party. Novation needs to be approved by both parties of the original contract and the new joining third party. Some amount of consideration must also be provided in the new contract in order for it to be novated. Now, let's see how novation works. Because here, the benefits and burden are transferred. Let us again use this example that the client and the main contractor has a direct contract. This time, the client engages a nominated contractor and also has a direct contract with the nominated contractor. The client wanted to transfer these risks and benefit of the nominated contract to the main contractor. So what he's going to do is to novate the contract of the nominated contractor to the main contractor. And once novated, the nominated contractor becomes a subcontractor to the main contractor. Because of taking the risks from the nominated contract, the client will pay the contractor or the main contractor certain amount of money. It may be by way of percentage to the awarded contract sum of the nominated subcontractor, or a fixed amount, or any other agreement that they are going to have. Because of the risks and benefits are already transferred to the main contractor, the direct contract between the client and the nominated contractor will now be done. So that is how novation works. It is important to remember that parties to a contract is fundamental to its existence. If you are not able to correctly identify the parties to the contract may be void or unenforceable. Therefore, due diligence is important. So how do you carry out due diligence when you form your contract or when you document the contract? During documentation, you have to make sure that the parties to a contract are named and ensure that the necessary details to identify these parties are correct. So how do you ensure that you have the correct information? For companies, you need to have the full name of the company and also the place of registry, because it might be that the company is not registered on to a place where the project will occur or will take place, and this company don't have the right to carry out works on that particular location. So you have to take note of that. And you must also have the company registration number and the registered address. For the company personnel that you are dealing with, you have to make sure that the person has a legal capacity to contract. This will be subject to applicable law. For example, different territories have different age requirement before a person can enter into a contract legally. Another thing to consider is that the person has a mental capacity to contract. So all of this will be subject to applicable law. Next is the authority of the person that you're dealing with. It means that the person is permitted by the company to sign and enter into a contract, because an individual may have legal capacity but not authorized by the organization. So any document that is signed by this particular personnel that is not authorized by the organization is not enforceable. Join me next on Silver Screen as we continue our discussion about conditions of contract. If you like the video, please hit the like button and share the video to your friends, especially those who are preparing for their APC. And if you haven't done yet, please subscribe to my YouTube channel and turn on the notification bell so that you will be notified every time I upload a new video. Thank you for watching and see you next episode.